Good evening. My name's James Stanger, and this video is about an issue with non-invasive pre-implantation genetic testing. And it's a verbatim content of a web page that's been submitted by the lawyers who undertook this class action and it's titled MONASH IVF $56 million settlement, what it means for informed consent in fertility care. And this is a full attribution to their content of the web page, and I make no further comment on it. Okay, so I'm found on the O'Brien solicitors, and there's their name, and this is where you can find the information, and this is the verbatim content from this. And all I'm doing is the aim of it is to spread the information out further so people are fully aware of what's happened. In August 2024, Monash IVF agreed to a $56 million settlement, $40 million in compensation plus $16 million in legal costs to resolve a class action brought by more than 700 patients who alleged that the company misled them about the accuracy of an embryo screening test. The case, approved by the Supreme Court of Victoria and formally resolved in early 2025, is one of the most significant medical negligence class actions in Australian fertility history. It raises questions about informed consent in fertility care that extend well beyond Monash IVF. So what was the Monash IVF class action about? Between May 2019 and October 2020, Monash IVF offered patients a non-invasive form of pre-implantation genetic testing called NIPGT, non-invasive pre-implantation genetic testing for aneuploidy. This test collected material from the fluid surrounding the embryo rather than removing a cell directly from the embryo itself as the standard invasive test PGT-A does. According to the plaintiff's pleading and reporting on the proceedings, patients were told that the NIPGT-A tests were indistinguishable from the invasive test in approximately 95% of cases. The class action alleged that this representation was false, with Monash IVF later acknowledged a concordance range of about 75 to 85% in public statements. Plaintiffs and media reports cited estimates suggesting that a substantial proportion of embryos classified as abnormal by the NIPGT-A may have been viable, with some reports referencing a figure in the range of 35%, although this reflects the asserted statistics from the proceedings rather than an independently verified scientific consensus. For patients who relied on these results, viable embryos were destroyed or not transferred. So what was the class action about? Monash IVF settled the proceedings on the 20th of August 2024 for a total of $56 million, comprising $40 million in compensation plus $6 million in legal costs, without admitting liability. The Supreme Court of Victoria approved the settlement terms, with the formal court hearing taking place in December 24. The Monash IVF settlement is a landmark for Australian fertility law, not because it established new legal principles, but because it applied the existing law of informed consent to a systematic disclosure failure affecting hundreds of patients at one of the country's most prominent fertility providers. The legal principle, why informed consent matters. The legal foundation of the Monash IVF proceedings was informed consent, the right of patients to receive accurate, complete, and non-misleading information about their medical treatment before agreeing to it. In Australian law, the duty to obtain informed consent was clarified by the High Court in Rogers versus Whittaker in 1992. That case established that a medical practitioner must disclose material risk and information that a reasonable patient in the plaintiff's position would want to know. Subsequent cases have reinforced that this duty applies not just to surgical risks, but to the accuracy of diagnostic tests and the limitations of medical procedures. In the Monash IVF context, the allegation was precise. Patients were told that the NIPGT-A test matched the invasive standard test in 95% of cases. That representation was false. Had patients been told the actual concordance rate, many would have made different decisions, choosing the invasive test, decline genetic test entirely, or proceeding to transfer an embryo that NIPGT-A had incorrectly classified as abnormal. What loss can be claimed in IVF negligent cases? The Monash IVF settlement illustrates the range of losses that can arise from negligent fertility treatment or inadequate disclosure. 1. The cost of IVF cycles that would not have been undertaken had accurate information been provided. 2. The cost of additional treatment made necessary by the original failure. 3. Pain and suffering, the physical burden of repeated egg retrievals, transfers, and failed procedures. 4. Psychological harm, the grief, anxiety, and trauma associated with preventable failed fertility treatment. 5. The loss of the chance to pursue a viable embryo that was wrongly classified as abnormal. And 6. In the most severe cases, permanent loss of the opportunity to have a biological child. Courts in Australia have consistently recognised that loss in the fertility context are not limited to economic harm. Psychological injury and profound life consequences of preventable fertility treatment failure are recognised heads of damage. The legal principles tested in MONASH IVF apply to any fertility provider that fails to give accurate and complete information about the risks and limitations of treatment. If you receive IVF treatment in Australia, the following questions are relevant. 1. Were you offered PGT-A testing through MONASH IVF between May 2019 and October 2020? You should seek specific advice on whether you fall within the settled class action and what options remain open to you. Were you given specific accuracy information about any embryo screening test, and was that information correct? Did you have embryos classified as normal and not transferred? Were the limitations of the testing method explained to you beforehand? Did you make decisions about your treatment based on representation a clinic made about test accuracy or success rates? Did you suffer physical, psychological, or financial loss as a result? Now, time limits and next steps. Time limits apply to medical negligence claims. In New South Wales, the standard limitation period is 3 years from the date you became aware or to reasonably have become aware of the negligence and the harm it caused. The date of awareness is the nuanced question that turns on the specific circumstances for each patient. Special advice is important for anyone considering whether the claim remains open. To learn more about negligent claims, visit your medical negligence page. And that, I think I need to stop. I make no further comment on this. This is purely and simply a public service to anyone who looks at videos on my website about the nature of informed consent. And I'd like to stop at this stage and say thank you for listening.